It is with a deep sense of honour, duty, and gravity that I rise to express my profound concerns about the proposed Comox Treaty. I urge my esteemed colleagues to vote against Bill 20, which would ratify and constitutionalize this fundamentally misguided agreement. First, this treaty expands Indigenous claims. It does not settle them. A treaty is meant to bring finality. This one does the opposite. It expressly admits to the existence and ongoing force of Aboriginal title. The document describes itself as a living agreement, with mandatory periodic renegotiations and amendments. Far from extinguishing Aboriginal title claims as it should, this agreement keeps the coals burning so that every breeze that blows from the court or another negotiation table will revive Comox claims and spark new ones. Even worse, this treaty expands these rights and the uncertainty they create. How? Through the United Nations Declaration on the Rights of Indigenous People, UNDRIP, whose objective and anti-Canadian claims are directly embedded into this treaty. Yes, Mr. Speaker, the same UN declaration that this NDP government gave the force of law with in this province in 2019. The same law which the Premier himself now admits is an existential threat to British Columbia. On its very first page, the treaty affirms UNDRIP and recognizes what are described as inherent rights to land, lawmaking authority, and governance powers within a large geographical area of Vancouver Island. These are the kind of powers ordinarily reserved for sovereign nations, but they are being given to a group of approximately 350 people, only 100 or so of those that live on the reserve. A group this size is more of an extended family than a local government, let alone a sovereign nation. And our government is preparing to grant them a broad array of national governance powers over a region that is roughly 7,000 square kilometers in the heart of the Comox Valley, with approximately 70,000 non-Indigenous residents. With all due respect, Mr. Speaker, granting the powers of a sovereign nation state to an extended family group is absurd. Furthermore, embedding UNDRIP into a treaty undermines any legal certainty that a treaty might otherwise bring. It is legally schizophrenic to recognize broad, undefined, inherent, and thereby inalienable rights on the one hand, while purporting to define, limit, or settle Indigenous rights on the other, which is what this treaty does. This double meaning invites chiefs and their lawyers to claim in the future that while their Aboriginal rights may have been limited by the treaty, their UNDRIP-inspired inherent rights can be retrieved whenever they feel like it. In addition, this treaty does not even bar new court challenges. Comox retains the ability to challenge permitting decisions where it says consultation has been inadequate under the treaty framework. These consultation processes won't even provide fixed, fast, or final timelines for business and resource developments in this province. So in sum, this treaty provides no certainty whatsoever. In fact, it doesn't even attempt to reconcile the Comox Band with the historical reality of Crown sovereignty. On the contrary, it promotes UNDRIP's blood and soil theory that people with Indigenous ancestry have their own inherent rights based upon what are described as inextricable links to the land. That is why the first page of this bill says that British Columbia must reconcile the past presence of Indigenous people with the assertion of Crown sovereignty. But as recognized by the trial judge in the Delgamuukw court case, British sovereignty was not merely asserted, it was undeniably established. Sovereignty was established not through violent conquest, as in other parts of the world, but through the orderly extension and adoption of British laws, settlement, and institutions across this entire province. Crown sovereignty within British Columbia was unquestioned for over 100 years. Indigenous inhabitants were adopted by the Crown as subjects and supplied with food, medicine, education, and economic opportunities. It is true that colonial authorities entered a few treaties from time to facilitate settlement, but Canadian governments at all times welcomed Indigenous individuals to become full and equal subjects of the Crown through the process of enfranchisement. The good and honourable objective was to grant them all the rights enjoyed by all other citizens, regardless of racial ancestry. Enfranchisement offered the path out of the Indian Act and its racial isolation from broader society. But tragically, Mr. Speaker, this treaty would prolong the regrettable forms of race-based governance that prevail under the Indian Act. Only this time with the power of UNDRIP. It entrenches a form of Indigenous racial supremacy, granting peculiar and additional rights not belonging to other Canadian citizens. Even so, Mr. Speaker, many tribes vehemently oppose this treaty process. The uproar we see now from neighbouring groups proves the point. They say that these treaties before the House impinge on their own demands for sovereignty. We now have threats of blockades and other civil unrest as a result. Clearly, modern treaties are not a path to peace, stability, or progress. Mr. Speaker, these treaties have enraged neighbouring tribes. But how should the British Columbian taxpayers feel? They should be angry too. This treaty is a terrible deal. We already know that it fails to provide legal certainty by extinguishing Aboriginal title. Nevertheless, it grants large and ongoing wealth transfers as if it did. BC taxpayers get nothing, but they pay anyways. And this includes an upfront payment of $70 million in cash, various forest licenses and tenures, a commercial fisheries allocation, subsurface mineral rights, taxation powers, and additional agreements with BC regarding natural resource revenue, which are not included in the treaty itself. Nowhere in this treaty or the bill before the House has the government provided even an estimate of the total economic value of the cash, the land, and other wealth being transferred from British Columbians to the Comox Band Council. Nowhere. We have no idea what this treaty will cost. Is it $250 million? Is it $500 million? $1 billion? More? We don't know. And this government over here, they won't say. And what does this treaty accomplish, Mr. Speaker, for the 350 individual Comox Band members? Let's ask that question. Treaties are supposed to replace the dysfunctional system of Indian Act reserves which require federal government micromanagement and which do not give individual band members the right to own their own private properties. On an Indian reserve, members are treated as wards of the federal government who holds the title to the land in trust for the band. The Band Council typically has a lease arrangement whereby it manages the rental properties occupied by individual members. Land cannot be held in fee simple. Private property cannot exist. But the Comox Treaty does not solve this problem either. What it does is dictate that Indian reserve lands will be transformed into Comox lands. These lands are not distributed to the members directly in the form of private property, they are given to the Band Council to control. There are no guarantees that members will ever have the right to own their own homes, ever. This treaty just swaps one form of government-controlled housing with another form of government-controlled housing. What it does is give more rights to the Comox Band government, not its members. Why do treaties give rights to band elites, Mr. Speaker, and not band members? Because our governments and our courts have been captured by anti-Western, UNDRIP-inspired theories of inherent collective rights, including laws, lawmaking authority, and legal systems. There were, of course, no written laws when Europeans first arrived along the west coast of BC. There was no writing at all, in fact, no recorded history, no way to verify which tribe had conquered another for the time when prior inhabitants struggled for control over these lands after having arrived from the Bering Land Bridge 10 to 15,000 years prior. What you had was intense competition for resources and a brutal struggle for survival. You had tribal warfare, night raids, captives taken as slaves, children traded away, even cannibalism, Mr. Speaker. The establishment of Crown sovereignty and the inclusion of Indigenous people into Canada ended this era of brutality. One thing many people do not understand, possibly some members in the House, is that when UNDRIP, or a treaty like this one, gives rights to Indigenous governments, it is taking rights away from Canadian citizens. The chiefs get stronger, the people get weaker. Finally, Mr. Speaker, Aboriginal title is not only a denial of the gracious inclusion of Indigenous peoples within the Dominion of Canada as full and equal subjects of the Crown, it is also an obscene demand, a demand by unelected bodies to be elevated above our Constitution and placed beyond the reach of our democracy. It has no place in Canada or in any Western nation. Mr. Speaker, the only kind of solemn agreements that the legislators who first stood in this House would expect us to entertain, and the only constitutional instruments that we should now consider, are those which seek to perfect the legal union of Indigenous and non-Indigenous Canadians. Agreements which provide Indigenous people with the same responsibilities and opportunities as all of us, as fellow Canadians. That will include a full abolishment of the Indian Act and its system of racially segregated reserves, the full abolishment of Indian status and all other forms of racial distinction, the full abolishment of Aboriginal title, which has wreaked havoc on British Columbia's economy, undermined confidence in our heritage, laws, and institutions, and ultimately served no other purpose than to empower chiefs and other reconciliation industry elites. We should recommit ourselves to the true pursuit of the well-being of all Native people, something that our honourable founders have endeavoured to do since the earliest days of contact. We must urge our elected governments to pursue constitutional paths forward towards the full and final inclusion of Indigenous peoples as proud British Columbians and as equal citizens of the great Dominion of Canada. Thank you.